So all our attendees are here, so we will now begin with the session.
Yes.
A very good morning to one and all present here. Today I, Manini Sidhu, on behalf of the Center for Legal Studies, Geetaratan International Business School, welcome our esteemed guest, Advocate Amar Vivek sir, and all the attendees on today's personality development workshop on the topic Legal Career Counseling and Professional Need. Geetaratan International Business School was established in the year 2004. GIBS is affiliated to Guru Gobind Singh Indraprasth University, Delhi, and is approved by All India Council for Technical Education, Ministry of HRD, Government of India for Technical Courses, and the Bar Council of India for Law Courses. GIBS is currently offering postgraduate courses of MBA, MBA International Business, MCA, and undergraduate courses of BA, BBA, and BBALLB. GIBS has been graded A by National Assessment and Accreditation Council in the second cycle. GIBS has been rated A+ by State Fee Regulatory Committee, a fee committee of the Government of NCT of Delhi, and Guru Gobind Singh Indraprasth University. CLS GIBS has been rated the highest grading A by Joint Inspection Committee of the Government of NCT of Delhi and Guru Gobind Singh Indraprasth University. GIBS has been graded A by the Audit Cell of Guru Gobind Singh Indraprasth University consecutively for the past 8 years. Also, GIBS has been rated as number 2 Pan-India by Times Business School Survey consecutively for the year 2018 and 2019. The guest speaker of our PDW today is a well-known advocate, Mr. Amar Vivek sir. Sir is the founding partner at Avsailegal and is a practicing attorney with 30 years of experience of legal practice at the Honorable Supreme Court of India, High Courts, and the National Tribunals. Sir has handled more than 300 cases in the Supreme Court and about 7,700 matters in various high courts and other courts. Sir is presently conducting about 1,500 active cases in High Courts of Delhi, Himachal Pradesh, and Punjab and Haryana, and about 50 cases in the Honorable Supreme Court, in almost all fields of law, especially in the fields of constitutional law, administrative laws, intellectual property rights, commercial arbitration, civil matters, rent and eviction, land acquisition, mining, electricity regulatory, education and university, labor, environmental compliances across various forums, including NCLAT, IPR and Copyright Appellate Board, National Consumer Commission, NCLT, CCI, etc. We are honored to have you, sir. I would now take the opportunity to invite Mr. Amar Vivek, sir, to enlighten us with his immense pool of knowledge and experiences.
Thank you very much, ma'am, for your very kind words. I am really privileged and honored to be amongst my young friends. In fact, I always feel that a lawyer always remains a student. And the day he is not a student, he ceases to be a lawyer, because we have to continuously learn. And in legal profession, there is nothing like a person who has 30 years experience and a person who has 3 years experience. I'll tell you something very interesting, an interesting anecdote, and then I'll start the conversation. You see, once we were cross-examining some doctors who had certified the state of mind of a testator of a will, that he was in a sound disposing state of mind. So there was a senior doctor who had good experience. He had given his opinion, which was a very cursory, ambivalent, very sketchy, vague. But there was a junior doctor who had given a very, very well-written, well-documented, showing all the good reasons about the state of mind of the testator. So this case was continuing for several days. Fortunately or unfortunately, it was initially being heard by a bench headed by the Chief Justice. On a particular day, the Chief Justice was on leave. And there were two junior judges. I mean, junior in the sense they had newly been appointed. There's nothing like junior, senior judge. Judge is a judge. So very recent appointees, having maybe 1 or 2 years experience each, they were constituting the bench. and we were arguing. And the moment I started opening my arguments, the bench came down heavily on me and said that, see, there is a report of a senior doctor. We don't want to ignore it. He's an experienced doctor. He has given so many reports in his career. He has 30, 40 years standing. So we don't like to rely upon a junior doctor's report. So I was finding it very hard to defend myself and to convince the judges to look at the report of the senior doctor. Am I audible or there is a break? Can
So you're
somebody message
audible.
me, please?
So you're audible.
Okay. All right. So suddenly my screen froze, therefore. Anyway. So just trying my best to convince the judges, but some judges were not getting convinced. And then I suddenly, tried to divert the attention of the bench by saying that, milords, it's like this. The other day, a bench on observations. And today, this bench, it is relatively, comprising of judges who are new points, some observations. And the bench uses better reasoning than the bench headed by two relatively new judges. This will be an absurdity if somebody argues like this. So the bench immediately agreed. Yes, they said it will be an absurdity. And one should not see at the, seniority or experience or anything. So I think there is a note from the group that they can't hear me.
So your voice is breaking a little, but we
Voice
can
is
hear
breaking.
you. Yes,
Okay.
sir. I think there's some network issues.
All right. So now it is fine.
Yes, it's better now.
All right. All right. Thank you.
Thank you.
So idea is that on a day, how we perform. Suppose there is a match, and but century, he wins the day. So similarly, in the field of law, I would say what matters. What is your credential? What is your opinions?
So I'm sorry to interrupt, but your voice is breaking a lot, and we are not able to understand.
Can I just take off?
So can you please repeat?
Can I again connect myself?
Yes, sir. So, sure, sir. Please.
Good morning. Is it better now?
Hello.
Manini ma'am, I think we should continue and ask sir to continue the lecture because this is the connectivity issue at individual's end. Probably you're not able to hear, but I'm able to hear, or some other students. So this is an individual system. I think we should let Sir, continue with the
Okay,
lecture.
ma'am. Ma'am, actually, the students were writing in the chat box that nobody is able to hear. That's why.
Okay, I think sir is connected again.
Yeah. Is it better, ma'am, now?
Yes, sir,
Yes,
it
sir.
is better. It is better. Please
Okay.
continue, sir.
Okay. Sorry for
No, sir, this is
some
just
glitches
an
from my side.
right. Please continue, sir.
All right. So basically, what matters the most is how you perform on a particular day. So this is what I tell my young friends, that when we bring about freshness, when we have ideas which work hard, parallel. Again, I think there is a break, or
So it's breaking, but it's coming back again also.
I am seeing some, because from my side the internet signals, I am seeing all the bars,
So now it's
but
clear.
my screen is getting frozen.
Yes, so your video is not that clear, but your audio is clear, sir.
Audio is now clear.
Audio is clear, sir.
All right. So and it is not clear. Then
Yes, sir. Okay.
Manini ma'am, could you please
Yes,
call
ma'am.
sir to join?
Yes, ma'am. I was just trying to connect him only. His phone is not reachable.
Okay. Dear students, kindly be patient and be there with us for the lecture to continue. Sir will be joining soon. So please be there and have patience.
Ma'am, sir is not able to join back, so I've asked him to switch off his internet connection and turn it back on. So he's trying that, and we'll be joining in a minute.
Okay. Sir has joined.
hello, good morning, ma'am.
Yes, sir.
Yes,
Is
sir. Good
everything
morning.
good, sir?
I have tried to enter through an alternate connection.
It's
Yes,
better,
sir.
sir.
It's
It's
better.
better. We can hear you.
All right.
We can see you as well. There is not a problem.
All right. So anyway, so all I want to share with all of you is that what is most important is how we prepare ourselves. You see, most of us, we rely on what is our daily schedule, our textbook. We don't like to go into the nuances fineness, enrichment. Now, suppose I am to ask you, what is the day today? Can you please send your response in the chat box? What is the day today? I need your answers in the chat box. Somebody is attempting? Okay. Very simple. Somebody says it's Wednesday today. Anybody else? What is the day today? Well, today happens to be the birthday of our constitutional father, Baba Saheb Ambedkar. Now, what happens is that we just don't look around the surroundings. A lawyer will always, gather the surroundings, try to make out as to what is happening. So unless we look at our surroundings, we cannot develop that legal bent of mind. Now, you see, we have all studied constitutional law. We have all studied principles of law. But what we lack is proper application thereof. This application, I can't say that it will be developed overnight. Things take their own time. But we need to have hunger. Now, I always follow a diet of 4 hours. I say that each of us must have a diet of 4 hours every day. Now, what are the 4 hours? The first hour is reading. Reading one good judgment of Supreme Court every day. You see, our Supreme Court, various honorable high courts have rendered good many judgments. As a lawyer, it's my duty to refer to all, study them all. But when will I study? Suppose I become a busy professional, then what I will be doing is, I will be busy in my day-to-day work. So when will I read them? Today, I should not consider that we are only students. Someday, when we become lawyers, we will study. Or someday, when we get cases, we will study. Our preparation must start from today. For instance, if I am to ask you that in the recent past, Supreme Court authored a very good judgment on individual liberty or right to grant bail. Can anybody tell me which is that judgment, which in the recent past Supreme Court has rendered? I'll expect answers in the chat box again. A recent judgment, which is a path breaker given by the Supreme Court in the matter of individual liberty or bail, right to bail. Who's writing? Anybody? Please attempt even if it is wrong. Don't worry. Nobody will deduct your marks. A recent judgment by Supreme Court in the matter of individual liberty and right to bail. You can hear the question, no?
Yes, so you're perfectly audible.
Yes. Who's answering? No one? So I pass on the question. Haven't we seen Arnab Goswami's bail case? Recently, Supreme Court, yes, Anusha has come. So did we actually read that judgment, or we only referred the newspapers? We should read that judgment. You see, today is an age of information technology. So in the age of international information technology, everything is available on the click of button. We have access to everything. Earlier days, when we were students in 1984, we used to subscribe to some journals, and then the judgments will come after 6 months or 7 months. But today, in the morning, the judgment is rendered, and in the afternoon, the text is available. But our problem is that we don't like to read. In the newspaper also, suppose I am to read a newspaper, what we will read? We'll read maybe sports page, we'll read maybe, the cinema page, or some here and there stories and all that. Or maybe nowadays we'll read the number of corona patients. But we don't read the content which we as lawyers, as responsible citizens should read. So this is a problem. Now, recently there was union budget. How many of us would have attempted to find out what is the budget? What are the principles? What are the improvements? What are the deficiencies? So this is our duty to read them. And I'm sure when we are alert enough, when we focus our energies at the day-to-day developments, we'll be able to pick up many things. Recently, Supreme Court has given another path-breaking judgment. Supreme Court says that during COVID period, the cases which were not instituted, the delay in instituting those cases will be condoned, and Supreme Court has given from probably 8th or 9th March, 90 days time, that in 90 days, if the cases are filed, which were not filed last 1 year, they will be treated as within limitation. So again, a path-breaking judgment by the Supreme Court. Then Supreme Court has given a judgment on loan moratorium, that people who suffered bad loans, who had suffered losses in the business, they will be given moratorium. So I was coming on the first R. First R is read one good judgment of Supreme Court every day. One may miss one's breakfast or lunch or dinner, but one should not miss reading one judgment every day. Now the second R. Second R is writing. You see, most of us, we get used to, either writing on the computer or writing in social media, but we do not write with pen, or we do not write as an author. So suppose I have read a good judgment. I have read, let's say, Arnab Goswami's case. Why can't I write a critique on that, a comment on that, initiate discussion on that? After all, I'm a student of law. For instance, nowadays, this farmers' drill is going on for a long time. There is a constant fight and in the contentious issues of farm laws. How many of us would have actually read those laws? How many of us would have actually tried to go deep into the question as to what is the root of the problem? What does government contemplate? What do farmers want? Why farmer unions are protesting? So how many of us would have tried to go into that question? If we have tried to go into that question, why don't we write something? We may write a blog. I don't write some WhatsApp message. This is bad, this is good. No. I am not asking you to join the controversy. I am saying, as a lawyer, from bird's eye view, we should understand the issue. So Sayam Khatri has said that he has read all the farm laws. Very good. Maybe Sayam Khatri can email me an article if he has written anything on my email, and I will definitely like to respond to him, and find out as to what is the work which he has done. I have sent you my email. So now we all know the controversy of CAA. So CAA evoked a lot of protest. What is CAA? And CAA, is a project which Government of India initiated, and it was the poll promise, poll manifesto of so many things. But the question is, we should be alive to the controversy. So one question I am getting from Kushagra is that there are so many judgments by the Supreme Court. How do we know which is relevant and important? You see, Kushagra, it is like this, that suppose I plan to climb the mountain. I say I want to scale the Mount Everest. So I should not be planning that first day I will go to such and such place, then I will go to Kanchenjunga, I'll do this. I will start the practice today. So what I will suggest is that even in your textbook, even in your daily routine, we come across so many judgments. For instance, I would say Menka Gandhi's case, Minerva Mills case. These are the basic cases on natural justice. How many of us would have actually read those cases? We just read them from the textbook. What is quoted, one passage in the textbook. Basically, penchant for reading means when we go, how many judges are there which comprise the bench? What is the ratio? How the arguments are addressed? How the arguments are dealt? What is the ratio? How the judges have, tried to hit the controversy and decide it. So this is what is of utmost importance. And those of you, like I am getting message from Shivangi also that, they have done some work. So whatever you have done, please, you share with me and I will revert back to you on this. That will lead to our third R. So our third R is enrichment. You see, every day we cannot rely merely on what we do in routine every day. We have to read the views of certain celebrated authors, maybe MC Chagla, maybe Krishna Iyer, maybe, Sirvai or Palkiwala. So there are so many good books and material available in the market. Even if I read 2 pages, even if I read, few passages every day, as a routine, I'm saying, let's make a habit that every day we must inculcate the habit of enriching ourselves. How many of us can say that I have made a vocabulary? Every day I like to learn 5 new words. I write down 5 new words in my notebook. I write down their meanings and try to learn those 5 words every day. That is enrichment. How many of us are in habit of sitting with a dictionary or with the Google grammar to find out the meanings? Maybe when we read one word, we don't know the meaning. At that time, we may find out the meaning. But how many of us religiously like to write down 5 words every day? 5 new words, 150 words a month. After all, tomorrow we will be going to the topmost court of the country. Our vocabulary should also be rich. So we need to enrich ourselves by referring to renowned authors, their writings, and then, improving upon the vocabulary, improving upon the language, and improving upon our own expression. So first 3 of these R's, which I've discussed with you, reading, writing, and enrichment. This is how we will be adding a value to ourselves. Many of us, we feel that we should go to the topmost law firm for internship, or we should be able to get a placement in topmost law firm. But how do we get that done? We need some reference, we need some connection, isn't it? But suppose we have none, then what do? I'll give you an instance. About 10-12 years back, I had a intern from Amity Law School. Now, she came across an article written by the renowned environmentalist lawyer of the country, Mr. M.C. Mehta. Now, having read that article, she wrote a critic on that and mailed it to him. She was able to locate his email and mail it to him. Now, after 2 or 3 days, she gets a response that Mr. Mehta would like to speak to you. So he fixed an appointment with her, and she happened to visit him in his chambers. Now, she tells me when she went to his chambers, she found all big industrialists sitting there who had appointments with him, and this girl's appointment was already fixed. So she went and saw Mr. Mehta. Now, Mr. Mehta was very busy that day. So he told this girl, he says, "Ma'am, today I am very busy. I just called you for a purpose. There is a conference in Switzerland for which I am sponsoring you. Here are the tickets and here is the sponsorship. You go and attend that conference on my behalf. And after the conference, please write a note for me, mail it to me, and then we'll fix the appointment once again." So how did it happen? This happened because this girl enriched herself. She made herself special. She did nothing extraordinary. She just read an article, wrote a critic, wrote her views, and shared it with the man. And the man felt impressed. So why can't we likewise create a specialty in ourselves? There'll be law firms. Suppose I go for interview for one of the law firms to get internship. They'll ask me, what are your credentials? How many books have you studied? What judgments have you studied? What articles have you written? So today is a age of competition. So how do I get a cutting edge? I'll get cutting edge when I do all this basic work. So this is of extreme importance. I can assure you, some of you may agree or not with me, we utilize only 15% of our time every day. 85% of our time is not utilized. Whether we are students or we are professionals or we are anything. So if we can rationalize our time, we can increase that 15% window to 50% or 60%, it will make a lot of change in our lives. It will bring about so many new things in our lives. We have a wonderful person like Kalam who has authored so many books. We have Mahatma Gandhi, father of our nation. So there are Western people from overseas who write about him, who study him. But we as Indians feel shy. Why? He's father of nation. There must be something that is so extraordinary about him that Louis Fisher wrote that generations will come, but they will not be able to believe that such a man ever walked on earth in flesh and blood. And a time will come when people will lose distinction between Lord Rama and Mahatma Gandhi. This is a foreigner who has written about him. So there must be something unique. So why can't we read that? His ideas on Panchayati movement, his ideas about cleanliness, his ideas about how an orderly nation can be built. He's written books and articles. So similarly, we need to inculcate all that. And I'm telling you, in a court of law, merely repeating the arguments of a case will not matter. Merely sticking to the law point will not matter. What will matter is how well equipped we are how enriched we are, so that when a tough moment comes in the court of law, you see, a judge has to hear maybe 100 cases a day. My case is just the number, maybe number 87. And by the time my turn comes, the judge is already so overburdened, the judge is already so overworked, that by the time my case reaches, he would have felt tired. After all, he's a human being. So at that time, if I don't bring freshness, if I don't bring a change in the style of my arguments, how will I be able to present my case and get relief from him? And for a routine case, yes, it is possible 2 plus 2, 4. I cite one precedent and get a relief. But suppose I have to present a new proposition of law, a unique proposition of law. How would I work it out? So therefore, it requires lot of study. It requires lot of focus on me. And that focus is me and me alone. And now I come to the fourth R. The fourth R is what we don't do in the court of law every day. Argument. We never argue. We only articulate. The moment a child argues with parent, he's gone. The moment a student argues with a teacher, he's gone. Similarly, if a lawyer argues with a judge, he'll not get relief. We only need to articulate. We need to present. We need to express. How many of us are able to express ourselves? Express ourselves maybe in a blog, or maybe in front of a mirror, or maybe while going alone in the car, or maybe talking amongst ourselves with few of our friends. See, articulation is something. Suppose I have a petition running into 1000 pages. I should be able to give its crux in 1 minute, maybe in 10 words. Sometimes when I utter the first word before the court, that is what is most important. If I utter the first word wrong, I'm lost. That is the importance of arguing before Supreme Court and High Courts. So therefore, my very sincere advice to all of us, that we must rely upon this diet, daily diet of 4 hours, so that we create a specialty in ourselves. And when we create a specialty in ourselves, I'm sure the leading law firms, they will come and search for us. People will look about for us. After all, those who excel and do very well in life, they are not airdropped. They are from amongst us only. So it depends how we utilize our time, how we are able to apply ourselves to an issue, and then come about it so that people are able to see how we stand out in the crowd. So this is how I feel that we must address ourselves. The second thing is that there is a question which always bothers you and bothers all of us. Should I be a specialist lawyer? Should I be specializing in criminal law or IPR or property laws, infrastructure, arbitration, commercial litigation? You see, one should not restrict oneself, at least at the beginning of the career. One should take what comes to us naturally. A lawyer is a lawyer of dealing with legal propositions. You please look at Supreme Court. I can't point out that a particular senior lawyer deals only with a particular type of cases. They do all-in-one work. The judges of the Supreme Court, I can't characterize them or christen them or categorize them that Mr. So-and-so justice is expert in criminal law. They deal all kind of cases. So similarly, we as law students and as young lawyers, we also must be open to any field of law. We should not restrict ourselves. So this is my general observation on our day-to-day conduct as a lawyer. And let me tell you one thing, that suppose I am reading a simple proposition of contract law. While reading that proposition, I may see 2-3 judgments which might be quoted in my textbook. I should make it a point that very day to go through those judgments in details. Write a note about those judgments in my notebook, and then only I should finish my chapter. I should not feel shy that whatever has been written in the textbook or whatever has been discussed in the class by my teacher, that should be enough for me. No, that's not the approach. Unless I add originality, I add ingenuity, I cannot be successful in life. So this is one of the principles which we must follow day in and day out. See, as far as I am there, I can continue. I can continue like this for any number of minutes. But if you have any questions, if you have any points, if you have any comments, I would really welcome them, and I'll try to address them to the best of my ability. I have so many anecdotes to share with you. So I am getting one question which I would like to answer immediately from Arsha. So Arsha is saying that ADR is another upcoming field, and what is my take? You see, you are absolutely right that the litigation today has become so burdensome, has become so expensive, has become so time consuming that the litigants have begun to realize that it's better to settle. It's better to shortcut the litigation instead of setting up a trial, litigating for 10 years, 20 years, and then reaching nowhere. So ADR, I would say, is not a new field of law. It's a new approach towards law. It's a new outlook towards law. A lawyer, a litigant, a law student, they have to adapt themselves to this new outlook of ADR. ADR gives the flavor to the litigation. Just like, I'm having my daily meals, but at the end of meal, I may like something sweet. So similarly, ADR, I would say, is something which is the flavor, which remains at the end. So if I am engaging two fighting parties, husband and wife, in a divorce case for 10 years, and ultimately they vomit out their entire embitterment in the court proceedings, and they wash their dirty linen in the court, what I will get at the end is a breakup only. A breakup has already happened. They might have children. They might have suffered. But if I can introduce as a lawyer ADR in their mind and give them the spirit that please curtail the unnecessary litigation, try, if you don't agree, try at least agree to disagree, and try to cut short the litigation as early as possible. So good question, Arsha. It's a good way to look at the litigation. Today, mediation, ADR is no doubt, converting the traditional litigation into modern outlook. And I'm sure this is one way to reduce the burden. It is one way to cut short the litigation. So I was coming on a few of the anecdotes which I have to share with you, just to give you an idea that how the litigation, is the in thing for a lawyer. Once I was arguing a case in a court of sessions, and the judge over there, she was admonishing an accused who was an overseas. He was a Kenyan resident. So he said, ma'am, I can't engage a lawyer. So the judge asked me that, would you like to represent him as an amicus? And I agreed. The allegation against this man was that he had gone to fill petrol in his scooter at around 9 p.m. one cold December evening in Chandigarh, and he had handed over 100 rupees note to the attendant, got petrol worth 50 rupees, and he was waiting for the balance 50 rupees, but the attendant was not coming back, and he waited for 10 minutes, 15 minutes, 20 minutes, and finally when his patience ran out, he went inside, scolded that attendant, even caught him by a collar, had a virtual scuffle with him, asking 50 rupees back. And finally, police came, because in the meantime, the petrol attendant had called the police. He suspected the note to be fake. And the police came and searched upon the person of this man and found 9 fake 100 rupees notes in his person and one with the salesperson of the petrol station. So they booked him on the fake currency and they wanted to prosecute him. And he did not have a lawyer, so I was appointed his amicus. So I went through his case. The judge told me that she was not going to grant him bail because he could run away. But the judge said that she could conclude the trial in 2 or 3 days. So the witnesses were summoned. The first witness was the petrol station attendant. Now you see, in this case, I had a handicap. I could not interact with the accused for longer time. The reason being that accused was lodged in the prison and he was not able to evoke confidence that somebody will help him out. He had seen rough and tough, so he was not able to believe us very easily, and he would not share his ideas very easily. So I could get a very limited audience with him for 10-15 minutes, and based upon that I prepared my notes. And when the petrol station attendant came, I had to cross-examine him, and I cross-examined him. See, this man was asking for petrol, asking for his balance 50 rupees. He was waiting. Is it correct that he kept on waiting for half an hour? Is it correct that he came and fought with you, he held your collar, he abused you, he wanted 50 rupees back? Is it correct that between the time when you called the police and police finally came, a period of more than 40 minutes had elapsed, and during 40 minutes he did not run away, he kept on standing there, he kept on asking for his money? These were the questions which I broadly asked him. So next day I was slightly held up in the High Court when my colleague called me that, sir, there is a government fingerprint expert, a forensic science expert. He has come, he has handed over a thick report in the court. He has compared the notes, and in that report he has mentioned that the notes are fake, and the judge is saying he's a formal witness, so probably no cross-examination. So I told her, I said, no, please wait. I'll be coming to the court and putting some questions to the man. So once I reached the court, the judge also asked me, he says, Mr. Vivek, why ask some questions? He's only a formal witness. I said, no, Your Honor, I may like to ask him 2-3 questions. So I just flipped through the voluminous report. And to tell you frankly, I was not prepared. I did not know what questions to ask him. But I just cursory glance at the report and I started asking him, sir, what is your qualification? He says, I have MSc so-and-so, PhD so-and-so, diploma in so-and-so, so-and-so. All right. So for how long you are in the field of document analysis, forensic science? Sir, how many testimonies you have rendered in the courts on such type of cases? He said more than 100. Then I asked him, I said, sir, how many man hours did you put in to compare these notes? 20 hours, 30 hours, 40 hours, 50 hours. So he said about 40 hours. I said, sir, have you compared these notes only with a bare eye, naked eye, or you have used some appliances, maybe microscopic lens, ultraviolet lamp, or whatever, scientific tools? So he said, no, I use these gadgets, and then I reached my conclusion. Then I asked him, sir, did you work all alone in your analysis, or you had a team? You had some junior draftsman, senior draftsman, some this expert, that expert. So he said, no, we were a team of 4 or 5 people, and this is how we. So I said, that's all. These are the questions I wanted to ask. The judge looked at me quizzingly and said, Mr. Counsel, I thought that you are a hardworking counsel. Why did you ask all these silly questions? I said, Your Honor, in this case, I don't want to lead any defense evidence. I am ready for the final arguments right now. So I argued, I said, my man is innocent. He did not know that the notes in his hands are fake. Knowing notes to be fake, then using them is an offense. He did not know. How he did not know? The circumstantial evidence shows he did not run away when he handed over a so-called fake note to the petrol station attendant. He kept on waiting there. He kept on asking for the refund. Had he known that the note is fake, the moment he would have come to know that the petrol station attendant is not coming out, he would have run away. So he kept on waiting there. And second thing, an Indian forensic science expert with 30 years experience, with so many qualifications, sat for 40 hours along with a team of 4 people, and not with bare eye, naked eye, but with all these scientific gadgets, came to the conclusion that these notes are fake. So he could not make out that the notes are fake. So how could a foreigner who does not know Indian currency that much come to know that the Indian currency is fake? So what I want to tell you is that a lawyer has to be prepared ever. A lawyer cannot say that, no, I'll prepare for this case some other day. A lawyer has to have the insight through the total knowledge of his case. Just like an architect, he draws a plan. First, he develops the site plan, and then he fits in where the building will come and how it will come and things like that. So similarly, a lawyer at the start of his case has to have the entire case and the brief in his presence. Live up with it, sleep with it, eat with it, and then only the lawyer can enunciate the legal principles that are involved there. So this is how I would like to advise all of you, that please don't feel complacent. Legal field is a full-time field. It is not a story where 2 teachers were going outside the house of Mr. J.R.D. Tata and discussing that how much Tata must be earning every day. So somebody said he must be earning 1 lakh per day. He said, I would have certainly earned more than him. He said, how? He said, I would have also taken 2 tuitions in addition to my corporate work. So lawyer job is a full-time job. He cannot be part-time on the job. If I candidly and frankly share with you my sleeping hours, I can tell you I sleep only between 4 a.m. to 7 a.m. every day. Barely 2.5 to 3 hours. Because whole night I am on my table, and this is how a lawyer has to put in the work. I'm not threatening you. I'm not trying to scare you, but I'm trying to prepare you that we need to be whole-time lawyers. We can't be part-time lawyers. And today, you are not students. You are already lawyers in the making. So from today onwards, you must start your work. So let me come back to your questions. Akanksha, is asking what are some of the niche areas of law. You see, when I was a young student in my school, maybe in 8th class or 9th class, I went to my teacher and I asked him, "Sir, in this book, can you mark the important questions or important topics?" So he said, "My dear student, you must read all black letters in this book." So similarly, Akanksha, we must read entire law. Let's not think of, only a few areas. Have the entire law in front of you. You never know, tomorrow some big businessman can come to you, some small man can come to you. Everybody will come to you with a legal proposition. So we must be ready with every legal proposition. Avya says, what is your advice to first generation lawyers? Well, first generation lawyers are lucky. They have freshness. They don't have the baggage of expectations on them. You see, we are not in the olden times when we were counted by our libraries. Let me tell you, all of you, nowadays I am under quarantine. My mother was found positive few days back. I am in my bedroom and I don't have library here. So I am attending all my work, including my court virtual proceedings, from my bedroom only. So a lawyer only needs preparation. A lawyer only needs one's own capability, one's own time to study. So he doesn't require, family. He doesn't require connections. So hope Avya is satisfied with this answer. Ruchika says articulation is very important. So how to improve speaking skills as to improve articulation? By speaking. Well, I speak in front of a mirror, even today. Some people may laugh at me. I speak in my car when I'm driving and I'm alone. If I'm driving with a driver, I put something ahead of me and I keep arguing. I like to argue in front of my colleagues. I like to argue in the street when I'm walking. And that gives me my speaking skills. I keep rehearsing. And sometimes before I have to argue, I like to hum a song, just to reduce my stress. Raghav says, future in cyber law. Well, law has to be based on cyber in the coming times. We see so many cases, rising number of cases. Just Punjab and Haryana High Court 3 days back dealt with a case. I don't know how many of you know about it. A lady lawyer wanted to sue Prince Harry for breach in promise in not marrying her. And the High Court rejected that case by saying it is a fantasy world she's living in. She maybe was corresponding to a fake ID of Prince Harry. And all this while she was led into the belief that she'll get married to him. So yes, cyber law, Raghav, is the in thing. I'm sure that we need to pick up the nuances and the fineness involved in the cyber crimes, because there are people who are selling land on moon. There are people who are selling cryptocurrency. There are people who are selling bitcoins. I don't know. Has anybody seen Bitcoin? Maybe somebody of you maybe like to purchase land on moon. I'm sure these are all cyber frauds. So this is my take. Please don't be engaged by Bitcoin and sue me. Well, Kushagre says that you should be specialized in a particular field of law. So what is your take? Yes, you should be specialized in law, not a particular field of law. I deal with every case. You give me every case, any case, in any field of law. I would love to do this. Even if the first case in a particular field comes to me, I would like to argue it with the same zeal and enthusiasm. I can tell you, see, few years back, there is a sports figure in our country. Her name is Dati Chand. Dati Chand was disqualified in an international event because she had certain hormones biologically coming to her, wherein she was having male hormones. She could not control them. She was not taking any drugs. but it was naturally biological feature. But the the organizers disqualified her, saying that no, she is developing male hormones. Therefore, even though she won a gold medal, she was disqualified. Now, she appealed against that. And she said, it is a biological development in me. I can't help it. So, the question is that she was represented by a very young lawyer, a new lawyer, who probably had no experience in this field of law. And she was represented by him, and she won the case, and she was restored the medal. So what I want to tell you is that a new field of law is nothing but application. So you need not to restrict yourself. We don't have the clear definition of obscenity. Yes, Bhavya. Obscenity is anything which is ridicule. It is my view that anything which is uncanny, anything which is unacceptable. You see, I really like that movie Pink, where Amitabh Bachchan said that what is most important is word no. So anything which is no is unacceptable. Well, Daman saying judiciary aspirant. You see, good that young lawyers should take to judiciary. But I have one caveat. And the caveat is that a judicial officer with 1 year experience, if he's appointed as a judicial officer, a lawyer with 20 years experience, 30 years experience will come and argue the principles of law in front of him. So if he is not well read, then there is a tendency of giving wrong judgment. Therefore, nothing wrong. It's a career. It gives you a good career. But idea is you should be well prepared. So if you are well prepared, if you're open, if you have everything at your hand, why can't you be a judicial aspirant? You should be. Why not? And from where we can start? Start today. Start today with the diet of 4 hours. I will tell you, there is a very good book by MC Chagla, Roses in December. There is a good book by Osborne, Problem of Proof. Start reading these good books. Understanding the manner the legal world works. Legal is nothing. Legal is common sense. Law is common sense. Our Indian Penal Code was enacted in 1960. Our Evidence Act was enacted in 1872. Our Land Acquisition Act till recently, which was in vogue, had been enacted in 1894. Our Civil Procedure Code has been enacted in 1908. Why these are applicable today in free India? Because they are common sense. Law is nothing but common sense. Anything which is common sense is law. So therefore, one needs no preparation. One just needs to have the understanding as to what are the basic principles. Is the field of criminal law suitable for women in the country? Yes. Why not, Shivangi? Why not? It is suitable, certainly. And you can get the examples from Rani Jethmalani. You can get the examples of Geeta Luthra. They're noted Supreme Court lawyers in criminal field. Law is as much as knowledge as it is psychology. Oh, do you agree? A lawyer must be aware enough to read the person in front of them, be a witness or suspect. See, I have a slight different view, Arsha. My job is not to study the person. You see, so many times I get misled by looking at the person. I should look at the facts. I should look at the enumeration of the facts, chronicling the happenings, events, then make up my mind whether I'm willing to take up the case or not. You are right. Even today, when a client comes to me, I always like to ask myself, should I accept his brief or should I refuse his brief? A lawyer must refuse briefs. A lawyer must not agree to every brief. He should not compromise with his principles. He must stick to his principles. So it is important that we sometimes don't like to be inspired by the case put up by the opposite side. But that, I think, comes with your practice. The moment you see a case, you read the facts, these are eloquent enough, you can easily make out what the person sitting in front of you is. And you can accordingly refuse the briefs, and it's a good habit to refuse the brief. So I think I must have answered all the questions, except Bhavya is saying, do you feel Indian laws are more female oriented? Well, this is a live topic. Why don't you write an article on this and share it with me? So maybe I can give my comments on this. See, law is growing. I can tell you, in 1984, when we were doing law, I had participated in a debate competition that there should be National Judicial Commission. The appointments of the judges should be like UPSC makes, recruitment for IAS. Similarly, throughout the country, judges should be recruited by a National Judicial Commission. So we had participated in that debate. Today, National Judicial Commission probably is becoming a reality. So it is growing. I had filed a PIL in 1989 in the High Court saying that the state should give free treatment to any patient who gets injured on the road in a road accident. The hospital should not ask for charges, for money, for treating anybody who's injured in a road accident. In that case, I had succeeded. But today, an act is coming in the parliament where they are saying every hospital will treat the patients free of charge. So please, law is nothing but what you believe. What you believe that, yes, you can turn this belief into reality. So please take your inner message and translate it into reality. After all, lawyers only lay down the law through the help of judges. So we all need to work on that. So Kushagre, it is considered that a lawyer must have a rational approach, how to gain the same. Well, start with 4 hours and you will have the desert. So I think largely I have been able to assist you. Wherever I have not been, you are welcome to interact with me. I have already shared my mail ID, and I would also request the organizers that if any of the students want to interact with me, they are free.
Of course, sir. Thank you so much.
Yeah. For giving me an opportunity to interact with young minds, united minds.
So thank you for taking out the time, sir.
Thank you.
Thank you so much. The session was very enlightening and very informative. I'm sure the students are very happy.
Thank you. Thank you. I'll feel more happy when I see these students, stealing a march and joining and turning out to be the best amongst all. This will be my earnest wish and best wishes for them.
Thank you so much, sir.
Thank you. Thank you. I can exit, ma'am?
Yes, sir, you can. Thank you.
Thank you. All the best. Thank you.
Ma'am, Shivangi ma'am?
Yes, Malini ma'am.
Ma'am, should I end the event
Yes,
now?
yes, please end the event. Thank you so much, students, for being so participative and asking good questions.
Yes.
Thank you everybody for your cooperation and participation. Thank you.